Welcome to this video presentation in the series Being Transgender, in which we look at different aspects of this condition to help people better understand it. My name is Steph Polak, and in this particular video I will be looking at the laws and officialdom that relate to transgender folks to help address the many misunderstandings that are commonly held about these. It should be noted this video contains references to hate, abuse and violence and is applicable to the UK in the 2020s. As has been discussed in earlier videos, law and officialdom are just one of a number of areas where transgender folks encounter issues that are specific to their condition. Those with the law and officialdom largely arise because Western society, as opposed to most other societies, has had laws and associated processes that are based on historical and specific ideological beliefs about sex and gender, which are based on science, research and individually reported experiences, now outdated. Misunderstandings and confusion between physiological and neurobiological attributes of sex, gender and sexuality, what is biological and what is a social construct, and a belief that these are always intrinsically tied and are binary, has meant that those who naturally do not conform to these have not been well served. In fact, the term sex and gender are used interchangeably in law as if they were one and the same, when they are not. While the laws and related processes have been changing to better accommodate such folks, it has been a slow process, made all the worse by those who wanted to cling to their now disproven understandings and beliefs. So, what are the laws that are relevant to trans folks? Well, there are only two currently with specific references to being transgender: the Equalities Act 2010 and the Gender Recognition Act 2004. There are, of course, a whole raft of laws that are potentially relevant, but these apply to all, regardless of sex, gender or sexuality. Those laws that have specific trans references are the result of lobbying and legal cases taken through the courts by trans folks over many years to improve their recognition and lives within society. The Equalities Act brought together a number of disparate anti-discrimination laws into a single all-encompassing act. It highlights and specifically protects 9 characteristics that are commonly subject to prejudice and discrimination, and makes decisions, actions and segregation that are based in some significant way on these characteristics illegal. However, it does allow for exceptions where these can be justified with strong evidence and context, that is, show there is a real need as opposed to a hypothetical one. Finally, this Act doesn't actually define each characteristic. This is partly because it is impossible to create such a definition, even for sex, but also because of the way the law works. A claimant has to argue and prove they are protected under a specific characteristic and that they have been discriminated against because of it. The Gender Recognition Act addresses issues trans folks have had with law interdependency and the effect this has on government processes. We've always assumed biological gender is intrinsically aligned to sex, and so is recorded at birth in one of 2 socially constructed categories, using a brief assessment of sex characteristics. This historically couldn't be changed, and these categories were then embedded into other laws and processes. Marriage was only allowed between a registered female and a registered male. Retirement ages were different for males and females, and so on. For those who had undergone complete gender correction and were living full lives in the gender opposite of that on their birth certificate, these restrictions were both challenging and a nonsense. The Gender Recognition Act created a process for changing the registered gender, and so enabled these folks to get treated by the law and the government appropriately. It is called gender recognition as opposed to sex recognition because it recognises the difference between the two and only changes the sex mark on the birth certificate because this is the best mechanism to making this recognition applicable across legislation. However, for various reasons, it was enacted so as to only be applicable to those who had fully transitioned, with an arduous, one-way and binary-only application process. Finally, these other laws are important because, firstly, there are claims being made that the rights granted to trans folk provide loopholes in the law that endangers others. In fact, they don't, as the applicable laws apply to all regardless of sex and gender. Secondly, some of these have been recently enacted and make some of the benefits of the Gender Recognition Act somewhat obsolete, while finally, there is some much needed legislation pending that would significantly benefit trans folks. The Equality Act has been the subject of considerable focus by anti-trans activists in recent times. The basic principle of this act is that everyone should be treated equally and fairly in society, which has, of course, been a principal demand of feminism for many years. It identifies and protects 9 specific characteristics, some purely social constructs, some biologically related, that are commonly the subject of unreasonable segregation and discrimination. However, the law does also allow for exceptions to this basic principle, but makes it clear that these must pursue a legitimate aim and that the burden of showing that the exception applies rests on those seeking to rely on it. The need for a Catholic priest to be a celibate male, for example, would be an acceptable exception. One of those characteristics is gender reassignment, and, as with other characteristics, there is no absolute definition of this other than stating it as being someone who is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of gender reassignment. Of course, once a gender recognition certificate has been received, the individual is considered to be of the sex related to the corrected gender, and therefore assumes the protections provided for this. But while the law is pragmatic and has therefore been very effective, the anti-trans campaign has set about fostering misunderstandings about it, and has more recently been trying to discredit it by saying there are unanswerable conflicts between the protections offered to trans folks and those of other characteristics such as sex and belief. Initially, the idea promoted was that it was illegal for men to enter women's toilets and similar spaces, and that the trans-related laws would, or did, enable predatory men to get round this to prey on women. Though completely untrue, it has never been illegal for sound practical reasons for women to enter men's designated spaces or vice versa. Trans-related laws don't affect or provide loopholes in this or any other relevant laws, and predatory men, which are absolutely not what trans women are, rarely enter women's spaces for very good reasons. This straw man argument has gained traction among a group of narrow-minded activists. This has been further bolstered by totally fabricated stories that, for example, claim that hairy butch men have been allowed to enter women's changing rooms because they have claimed to be female on the inside. A subsequent attempt to get a judicial review of the Equality Act using these arguments was dismissed because there was, of course, no real evidence to substantiate the claims and therefore the need for a review. However, a co-temporal discrimination case that claimed that having gender-critical views was a belief protected under the Equalities Act was upheld, though it was heavily caveated, stating that this didn't mean the beliefs were true or meant that anti-trans rhetoric and actions intended to cause trans folks harms was acceptable. Since then, the arguments have moved on so that now what is being claimed is we're being forced to pretend trans folks have changed sex and to accept them breaking sex-based rules, such as accepting them in women's spaces. And we will be discriminated against for believing and stating our truth and for being forced to interact with men, which is what trans women are, against our will. Of course, there are no sex roles of the sort alluded to, and most designated spaces, activities and groups are actually gender-specific rather than sex-specific. There are not many instances where sex-specific designation might be necessary, and these are appropriately managed. The use of the same words for both, though, allows for deliberate misrepresentation. As for beliefs, well, a belief is something that is not based on facts or other evidence, and so cannot be disproved or contested. And yet the claim to have a belief that being trans is an ideology and that sex cannot be changed, so-called gender-critical views, is not matched by the evidence, making it highly contestable and therefore an opinion or a prejudice, not a protectable belief. And finally, although suggesting otherwise, this is a small minority group that have been shown not to speak for the majority of women, who focus solely on trans women to the exclusion of all others. That they will almost certainly have shared a designated space with trans women without being aware or taking issue, again, all indicates both prejudice and hypocrisy. That said, heavy continual lobbying by these activists has led to confused guidance about exceptions being issued by the Equality and Human Rights Commission and demands that the law be scrapped and the UK leave the ECHR by some right-wing politicians. At the end of the day, this doesn't seem to be about protecting rights or seeking equality, but about removing rights and establishing specific inequalities that match prejudiced and phobic views about a minority group with a natural biological condition. There has also been considerable heated argument and many false claims made in recent years about the Gender Recognition Act and the proposed reforms to this. Unravelling this involves understanding what the current process involves, what a gender recognition certificate granted by the Act provides, and importantly, does not provide, what the proposed reforms are and why, and how these stand up against the claims being made against them. As previously mentioned, applying for and acquiring a gender recognition certificate is the means under the Gender Recognition Act by which the law and the government corrects an individual's gender markers. The process is very demanding and can only be applied for at the very end of a full transition process, which in itself is hugely difficult and time-consuming. Social transition, that is moving to live permanently in the correct gender, is the first step in this process and must be undertaken before anything else, such as medical intervention, is provided. An initial requirement, amongst many other things, is to permanently change one's name and get this and the correct gender reflected by all those one interacts with in society. Partial change is not acceptable, which makes this a major undertaking and is the primary way of proving the truth of and commitment to a corrected gender. Only those who are genuine would and could do this. To do this, a deed poll and a letter from a GP or specialist consultant saying that permanent transition is taking place is used to change the name and gender markers on a complete range of accounts and ID documents, including passport, driving licence, land registry, company's house, banks, utilities, insurance, NHS work and school, and so on. This effectively enables one to live entirely normally and naturally in one's correct gender, just as is required. Only HMRC won't update gender markers, as any gender-specific entitlements can only be granted after receipt of a gender recognition certificate, though they will change pronouns and name. Some considerable time later, once transition and medical treatment has been fully completed, one can apply for a gender recognition certificate to change the registered gender used by the law. To do this, one must obtain a report from a registered gender specialist saying that one has been treated for gender dysphoria, and a second from a relevant consultant detailing all the treatment and surgery one has undergone. One must then sign an affidavit confirming that the gender correction will be permanent in front of a solicitor and produce multiple documents showing that one has lived in role in the corrected gender for 2 years, including your passport, driving license, and other identifying documents such as utility bills. If still married, confirmation from one's spouse that this change is agreed is required, alongside a completed application form and a fee. All of this is then put in front of a secret review panel who will decide if one has met the necessary criteria to be granted a certificate, and if so, one can then get the HMRC gender markers changed and relevant entitlements, an updated birth certificate, and, if applicable, a marriage certificate. So, what rights does a gender recognition certificate give? Or, more importantly, what doesn't it give? Well, the first thing a GRC doesn't give is any rights to single-sex spaces or activities, especially so-called safe spaces, be they men's safe spaces or women's safe spaces. These are governed by entirely different legislation, such as the Equality Act, which apply equally whatever one's sex or gender. Having a GRC, therefore, doesn't change or have any effect on these, and any claims that suggest otherwise, such as it allows men to access women's safe spaces, are simply not true and are, in fact, entirely false propaganda. Secondly, it doesn't enable one to change one's gender markers on those documents that do not provide any gender-specific entitlements, such as passports, driving licenses, and the similar. These can be changed right at the start of transition, which, in fact, is actually a requirement for applying for a gender recognition certificate. Thirdly, it's not required to marry. This was one of the main reasons for the original Act because, at the time, same-sex marriage was illegal, while it was not possible to change the sex registered at birth. This meant that without a GRC, those who had transitioned could not legally marry. However, the Same-Sex Marriages Act, subsequently introduced, has negated that, and it is now possible to legally marry regardless of sex and gender. Next up, it doesn't change one's retirement age. While there used to be different retirement ages for men and women, the drive for gender equality, as promoted by feminism, has meant these now have been levelled up, and there is now no difference. Neither does it affect prison placement. A range of factors are considered for the very few who do end up in prison, including not only the danger they pose to other prisoners, but the danger other prisoners pose to them. Equally, it doesn't determine the marker registered on the death certificate, and these days coroners will record what seems most appropriate. After all, what does it matter after one is dead? So, if these are not granted by having a GRC, what exactly is? Well, as discussed earlier, one can change one's HMRC gender marker and receive any applicable gender-specific entitlements. These, though, are actually very few and far between, a result of gender equalisation, though it does, ironically, include maternity and paternity leave. The only other benefit is the provision of protections of one's gender history. While some believe this means people can't ask about past history, this is not true. It does mean people who have acquired information about past gender history in an official capacity, say for DBS checks, cannot pass this on to anyone else without the individual's permission. However, the recent Data Protection Act actually supplants much of this benefit and in some way goes further. That said, there have been recent amendments following the Cass report, which allows history to be passed to those doing research without permission or notification. There are also some additional rules that tighten up the process further. it is a once only. That is, one cannot subsequently change one's mind and go back. Is only between male and female, uh, and vice versa, and misuse, such as using it fraudulently, is an offence, while, until recently, it has not been possible to appeal or get feedback should the panel refuse an application. Finally, it is difficult to obtain by those who can't or don't fully medical transition, while there is no recognition for intersex and non-binary folks, despite the significant numbers of these. Given this, it can only be applied for at the end of one's transition, when one has overcome all the challenges and has been living successfully in one's corrected gender for some time, and yet give so little. How often does one actually use one's birth certificate? It is hardly surprising that many consider the process pointless and don't bother. It really doesn't meet the needs for those for whom it is intended, especially those who don't fully meet the very strict criteria, and therefore has been considered in need of updating for quite some time now. There has been considerable consultation and analysis into reforming the Gender Recognition Act, and a self-registration process has subsequently been proposed, which moves the time from being able to apply from medical treatment completion to social transition completion. This would mean full medical transition was no longer requisite, which fitted with those for whom this was inappropriate. Full female to male medical treatment is challenging in the extreme, while recognising that social transition is in fact the primary requirement to societal acceptance. However, while such a revised process would be easier and more appropriate for those who required it, it also needed to provide sufficient barriers to ensure misuse was not possible. As a result, the process kept the need for a signed affidavit in front of a solicitor, multiple documentary proof, including changed passport, driving licence and so on, of having lived and enrolled in the correct gender for at least a year, as well as a completed application and the paying of a registration fee. All that would be removed from the process were the medical reports of diagnosis and treatment, agreement from a spouse, as this is no longer relevant, and the removal of the secret review panel. This self-registration process would still only give the same limited benefits, but would, importantly, still have the same conditions. A one-way only process, there would be no going back once done. It would still be between male and female and vice versa only, while misuse would still be an offence. This process is not only endorsed by the UN, but was recommended by the government panel reviewing the legislation, and has been adopted by an ever-increasing number of jurisdictions across the globe. And while this recommended reform in the UK doesn't propose the recognition of non-binary or intersex people, there are now also many jurisdictions across the globe that do. However, this has been met by considerable hostility from certain ideological groups who have been making claims and promoting propaganda that suggests these forms will be dangerous and cause harm. So what are these claims, and do they stand up to scrutiny? Well, aside from the claim it would enable someone to register as a horse or similar, which is just plain nonsense, it's only between male and female. The main claim is that the GRA self-ID, as it is put, would enable predatory men to access women's safe spaces. Now, firstly, as stated earlier, a GRC does not affect any access entitlements to specific spaces, safe or otherwise. So no, it doesn't enable this. Secondly, what is proposed is a self-registration process, not a self-ID process. Every human self-identifies their gender. It is just that most identify with the one they are assumed to have at birth. But let us analyse this further by looking at an individual, be they male or female, who wants to undertake some predatory action on another, an action that would be covered by legislation applicable to all. The Offences Against the Person Act, Sexual Offences Act, Voyeurism Act, and so on. They could enter any single sex or gender space with or without dressing up or having a GRC perfectly legally. But if they then sexually assaulted someone in that space, they would be breaking the law, the Sexual Offences Act. But, given the high likelihood of being witnessed, recorded and apprehended, it is unlikely they would do that, which is why such cases are uncommon. Instead, they are far more likely to find some private or secluded place where the chances of witnesses and apprehension were slim to commit such an assault. But what is being claimed is that, rather than these two options, they would choose to go through the revised gender recognition process. They would change their name by depol, get a letter from their GP or consultant saying they are changing gender, get the new name and gender applied across the board, including getting a new passport and driving license, then come out to all around and live and roll for a year, dressing and presenting in public, then sign an affidavit in front of a solicitor saying that gender correction will be permanent, then collect all the required documentation and apply and pay for a gender recognition certificate, and then, finally, after over a year, go into a single sex or gender space where no checks are made anyway and commit a sexual assault. Not only would this be easily traceable, but it is completely unrequired because, well, other than the Gender Recognition Act itself, they would still only be breaking the Sexual Offences Act. So in short, not only do these proposals not allow predators altered access to safe spaces, but even if they did, the idea that they would go through this process just to commit some form of predatory action is clearly absurd, especially when this is still a one-way process only with no going back. But these claims are really just part of a demonizing campaign, which is focusing purely on trans women to portray them as predatory men threatening innocent women and children. However, the reality and statistics show cisgender individuals are more likely to prey on and harm trans women, and indeed that cis folks are more likely to prey on and harm other cisgender individuals than trans folks are. Finally, as mentioned above, the process remains one way only and permanent. One has to be pretty certain before you undertake it, while the idea that trans women are a danger to cis women just doesn't stand up to scrutiny. Hormone treatment causes infertility. Most trans women are attracted to men, while they are actually more scared of being attacked in public spaces than their cis counterparts. And none of the many and growing number of jurisdictions that have this process in place report any of the claimed issues. But then, this is hardly surprising when one looks at this rationally and at the facts. The proposed reforms are safe, with sufficient barriers to ensure there can be no misuse, and go some way to addressing the issues with the way the current Gender Recognition Act works. However, recognition for intersex and non-binary folks will be needed at some point, just as is recognised in numerous other jurisdictions. Then there are two pieces of legislation that have been considered and are pending. The first is a ban on conversion therapy. This is practiced by those with extreme religious ideologies who claim being trans and homosexual is contrary to scriptures and the result of the forces of evil. Very specifically, they claim that being trans is not biological but an ideology, something you come to believe in. As an ideology, it is, therefore, only addressable by talking therapies designed to change those beliefs and to accept what they say are God's truths. This they call conversion therapy, and it involves praying to God to be cured, bullied into feeling guilt and shame about not being normal and as God intended, and to develop an aversion toward being trans. It also involves lengthy sessions being taught about evil and God's truths, and can even include electric shock therapy aimed at driving out evil. Although there are an odd case or two of claimed success, these do not stand up to any form of scientific scrutiny, and aside from these few very questionable cases, it is in fact repeatedly shown to achieve nothing. In fact, as a widely viewed form of torture, it actually causes severe psychological harm that significantly exacerbates the mental health issues already suffered by trans folks. As a result, the UN and the European Court of Human Rights, among many other organisations, recommend it is banned, as it already has been in a growing number of jurisdictions. A proposal to ban it in the UK has long been demanded by numerous relevant groups and promised by successive governments. However, powerful religious groups have stalled this by insisting being trans is an ideology, not biological, and therefore only treatable with talking therapies, that a ban would be a suppression of personal and religious rights, and that doctors who decided trans treatment was not required would fall foul of the law. While these arguments do not stand up to detailed examination, these groups have been sufficiently loud and forceful in their lobbying to keep the legislation delayed. The second area pending reform is the law related to hate crimes, that is, acts of violence or hostility directed at people because of who they are. While the law recognises hate crime based on various characteristics similar to those protected under the Equality Act, it has not treated these equally. Aggravated offences only apply to racial and religious hostility, while the stirring up offences don't cover disability or transgender identity. In 2020, the Law Commission reviewed and undertook a consultation on this and recommended in 2021 that the hate crime law be revised to give sexuality, disability and transgender identity the same levels of protection as race and religion. However, for sex and gender, it proposed a slightly different approach, that the offence for stirring up hatred be extended to cover stirring up hatred on the grounds of sex or gender, and that a separate, specific offence to tackle public sexual or gender harassment be considered. It also recommended that the protections to free speech be extended from conversations in private to conversations anywhere. Moreover, it proposed explicit protection for gender-critical views, criticism of foreign governments, discussion of cultural practices, immigration, asylum and citizenship policy, and neutral reporting of inflammatory hate crime speech. For the trans community, this presents something of a double-edged sword. There is no doubt, as has been discussed in other videos, there is a need to combat the growing tide of hate crime against trans folks, and the protections proposed would be a welcome step towards tackling this. However, this would be significantly negated by the exemption for those with gender-critical views. It is those with these that are the main instigators and undertakers of hate crime against the trans community. Quite where the line will be drawn between expressing a view and expressing hostility and hate towards trans folks will probably only be determined through case law. Though recommended, this legislation has not progressed significantly, partly because of recent political demonising of minority groups covered by these reforms. Though a version has been enacted in Scotland where, interestingly, the sky has not fallen in, as the anti-trans campaign has prophesied. So, in conclusion, there are only a few laws that have anything specifically relating to transgender folks. Of these, the Equality Act protects transgender folks, among others, from unfair treatment and discrimination that they have historically experienced. This is robust and pragmatic legislation, but is being attacked by the anti-trans campaigners, though their claims do not stand up to proper scrutiny. However, their intense lobbying has led to confused guidance and claims by some politicians that it should be scrapped alongside the UK leaving the European Court of Human Rights. In essence, it's not equality, these folks, just a different form of inequality based on prejudice. The Gender Recognition Act, which helps trans folks gain legal recognition post-transition, doesn't meet the needs of the trans community these days and is in need of updating, as per recent proposals. There is also a need for legislation to ban conversion therapy and updated hate crime legislation. However, all of these have been stalled by the anti-trans campaign's false claims, propaganda and lobbying. Ultimately, not only are these reforms required, but there needs to be a better recognition of intersex and non-binary individuals and to better differentiate between the two biological attributes of sex and gender. None of this is radical, though, and has been implemented in many other countries across the world without any of the issues the anti-trans campaign claim will arise, while these are supported by leading rights organisations such as the UN and ECHR. While ideology has stalled proposed law changes, it cannot deny nature and biology forever, and at some point these changes in law will occur. Thank you for watching this video, and I hope it gave you some better understanding of the laws that relate to transgender folks, the issues that exist with these, and the proposals to address them, what the true effects of these reforms will be, and the considerable false propaganda that has been spread by anti-trans campaigners related to all of this. If you'd like to learn more, please do look out for the other videos in this series.